Step 6. Pre-hearing conferences. In the family court, there are a series of pre-hearing conferences that are designed to help facilitate settlement, narrow the issues, and figure out what the case strategy is going to look like. A resolution management conference is an RMC. It's typically scheduled when there's attorney, sometimes if there's no attorney. A resolution management conference is about half an hour. You have to file a resolution statement prior to this. You can get that form on the Maricopa County Superior Court website. You want to be pretty specific in your resolution statement about exactly how you'd like the case to be resolved. You can't do a good RMC statement without the information that you gathered during discovery. How do you know how you want to specifically split the assets if you don't know exactly where they are, or exactly who owns them, or exactly what the terms of the interest rate are? That's why discovery's so important. The resolution management conference is a half an hour. It is in front of the judge that is assigned to your case at the courthouse. One quick thought on this: you have the ability to change your judge once as a matter of right before you go in front of the judge. If you are assigned a judge that you do not want for your case, you need to file a notice of exchange of judge before the RMC. At the RMC, you tell the judge how you want things to move forward. Not only do you tell them how you want the substantive issues to be resolved, for instance, I want Joey to go to X school or whatever kiddo issues you have going on, or money issues, but also, do you want certain experts appointed? Do you want to go to a parenting conference? Do you want to go to an ADR? Do you want a comprehensive family analysis? Do you want a drug testing for the other party? What sort of things do you need the judge to order? This is the time to ask. An early resolution conference is different. It is set with conciliation services. You go in front of the third-party mediator. It's you and the other party. Usually this is set when there's no attorneys, but sometimes attorneys get to go. One time I got to go and I was able to really help my client facilitate a fantastic settlement. It's set for 3 hours. It's different from an RMC. You're not in front of the judge and you don't have to file a RMC statement in advance, but you're gonna want to bring your evidence, because that's gonna help you negotiate. An ADR stands for Alternative Dispute Resolution. This is usually a judicial settlement conference. This is a 3-hour conference that is assigned to, not your judge, but a judge pro tem. They are usually an attorney or someone who has a lot of experience in family law. Their job is to help facilitate the settlement. Before you go to the ADR, you submit a confidential memorandum to that judge pro tem outlining all of your positions. This is like your pretrial statement. You are going to want to have all of the information that you need going into it. So again, this is why discovery is so important. The other pre-hearing conference that you might get is a return hearing or as a status conference. That is a little more loosely defined. Sometimes they take evidence, sometimes they don't. It's just an opportunity for you to talk to your judge. Sometimes it's telephonic, sometimes it's in person. Kind of come up with an idea of what's gonna happen. Maybe you're gonna set a case for trial, maybe you're gonna go over the remaining outstanding issues, etc. etc. Pre-hearing conferences are designed for a lot of different purposes, and we just talked about those. But the other thing to consider here throughout all of this is negotiations. You should make a good faith effort to look like you are negotiating. It's important. If you don't, you are exposed to paying the other party's attorney's fees. Unless you're in a position where you are afraid of the opposing party, you should try to engage in negotiations as much as possible. With that being said, there is many ways to do it. If you are afraid of the opposing party, you can engage in negotiations in writing or via attorneys. You don't have to do it yourself, it doesn't have to be in person. And when we do mediations or ADR, alternative dispute resolutions or judicial settlement conferences, we can absolutely have the parties be in different rooms where they never see each other. Another option is that one party, shows up an hour earlier than the other party so that you're never ever seeing each other. It is absolutely an option. Step 7. Trial preparation. Let's talk about trial prep. Now, all of this is kind of trial prep, but it's also negotiation prep and case prep and helping you to figure out what it is that you want. When you are engaged in trial prep, here's what you're looking at. You need to identify all of the remaining issues that have not been settled: property divisions, spousal maintenance, parenting time, child support. Once you've identified the issues, then you need to look at the law to figure out the elements of each issue, for instance child support. Child support is calculated pursuant to a calculator. The elements of child support are mom's income, dad's income, childcare expenses, healthcare expenses, any extraordinary expenses. You need to drill down into the elements and make sure that you have the information that you need to prove each of those elements. How do you prove mom's income, dad's income, healthcare expenses? This is all information you're going to need in order to prepare for trial and prove your case. You'll need to look at the statutes, which you can find under Title 25 of the Arizona Revised Statutes. That's all of the family law statutes. If you look at each one, you know, the one on parenting time will give you all the factors that the judge will consider when determining what the appropriate parenting time arrangement is. At this point you are gathering legal information and analyzing that legal information and applying your facts to that legal information. Get help, consult the statutes, lay legal advocates, people who have been doing this before, doc preparers, attorneys. Do what you need to do to make sure you're very well prepared and you can articulate the facts and have the evidence that the judge actually cares about. Pretrial statement. There was a question about a pretrial statement. The pretrial statement is the most important document in your entire case. I cannot emphasize enough how important this document is. This document identifies all of your issues, gives the procedural history and background of the case, cites the law, applies your facts to the law and incorporates exhibits. Last week I had a hearing with a client. The other side was represented as well. We had submitted to the judge a joint pretrial statement laying out here's what's happened in the case, here are the outstanding issues, here is the law, here is how we applied, each of us each attorney applied our facts to the law and we gave it to the judge in advance. When we walked in for trial that day, the judge had written up for us his presumptive findings. He had already drafted his ruling. He called us back in chambers. He said, look, I'm open to changing my mind once I hear a testimony, but here's what I'm thinking I'm gonna do. It was incredible. This tells you how important this document is. If you pay an attorney for one piece of your case, I recommend you pay them to do a pre-hearing statement for you, take your exhibits, apply your exhibits. The reason is you're going to use this as an outline for everything. We can talk more about that if you'd like. Alright, what are you going to use for witnesses and exhibits? How do you determine what you're going to use or who you're going to use? You look at your pretrial statement. Your pretrial statement shows you what fact you must prove. If you must prove mom's income, you know that you need an exhibit that shows dad's income. If you have to prove that mom never showed up to pick up little Johnny on time, then you're going to need exhibits that show that mom never picked up little Johnny on time or witnesses from the childcare center that can say that mom never picked up little Johnny on time. If there are facts really important to you that cannot be applied to an element, you don't get to use them. So if there is something that is very important to you, for instance your ex cheated on you and you're pissed and you want the judge to know, I don't blame you, you know, it makes sense that you are upset and you want the judge to know, but we have a no-fault divorce state, so it's really not relevant, unless we can show community waste of assets. If you put in legal argument and analysis related to waste, then you get to bring up the fact that your spouse cheated on you and spent all this money. You must figure out a way to get the facts that are important to you to apply to an element of a legal issue.